the oneness of a prosecuting service, the independence of the NPA to operate. It was probably the first 10 minutes of my exchange with Advocate Mokgoro last week.
I think I do, Advocate Power.
There was one or two questions that I think, because of the difference in position, that I probably wish to elaborate on with you. I thought your address to the inquiry in respect of prosecutorial independence was important, and I was wondering, at the level of prosecutorial independence from the ordinary prosecutor in a district court to the NDPP, in terms of internal interference. In other words, how do you preserve the prosecutor on the case's independence from those high up in the organization? And I'd like to have your comment on that.
In the organization, as you will understand, we have different positions. There will be prosecutors who, for lack of a better word, I will say they are junior prosecutors, but then they report to the senior public prosecutors, and then to the next ladder of the chief prosecutors, and then up to the director of public prosecutions, who can then delegate certain functions to the deputies. So the checks and balances are such that, say, for example, a member of a public raises a complaint one way or the other with regard to the case itself, the first point of call then becomes the senior prosecutor. It does not become the national director of public prosecutions. So things will have to be dealt with at that particular level. So those are the kinds of checks and balances that we actually employ. Yes. That does not necessarily mean that the SPP, that is now the senior prosecutor, can just willy-nilly give an instruction to the prosecutor to say, I do not like the way in which you are actually handling this case. There has to be something. There has to be something that is put on the desk of the SPP. The prosecutor in the lower court enjoys the same independence that any other prosecutor, whether he's in the high court, enjoys as well. Yes.
And there must, can I probably use the word respect? There must be that same kind of respect between, so you know, there's a chapter of the Constitution that talks about the spheres of government in terms of the local, provincial, and national government, and they talk about interdependent but distinct. And I sort of thought over the weekend that might be a way of describing the relationship between the DPP officers and the NDPP officers as well, that they are independent, interdependent, and distinct. Do you think that would be a fair type of analogy as to how a DPP office operates vis-a-vis a NDPP office?
Not entirely, Chairperson, because you see, if you read Section 20 of the NPA, with all the other provisions that are there, it speaks of conducting prosecution subject to the direction and control of the NPA. But then it goes further and gives gives provisions whereby the national director then may intervene. So we have an intervening process and we have an interviewing process. Ideally, in practice, we have come to accept that you would not want a situation whereby an NDPP just, you know, kind of interferes with the functioning of a DPP. But nothing stops the NDPP in law to intervene in any particular case at any stage. Yes.
But That intervention must, of course, be grounded in law, and that intervention must be mindful of the independence of the prosecutor at that DPP office as well. Would you agree with that?
Certainly, it has got to be grounded in law. You must intervene as an NDPP when you are supposed to be say, for example, there is a situation whereby certain policy considerations has not been taken care of by the DPP, then you have a right to intervene as an NDPP. Remember, you intervene on the DPP's exercise of power, and not necessarily on a deputy director of public prosecutions or on the SPP downwards, because those ones, they resort under the powers and control of the director of public prosecutions. So that's just the difference.
Now, when Section 179 was initially contemplated and drafted, one of the things that the drafters wanted to guard against was political interference with prosecutorial independence. That was the primary, if one looks at the certification process, that was the primary protection which was being offered to make sure that politics don't interfere with prosecutorial decisions. You agree with that?
I agree, very much so.
Now, when can a minister actually interfere with not necessarily a prosecutorial decision, but any decision which an NDPP takes? Ever? Never? Or is there somewhere in between?
Never. It's a definite never. That is one of the things that makes our constitution shines all over. I had an opportunity to go, in one of the countries where I found that, actually the ministers are termed as attorney generals, and in that instance, they have a right to even direct on how the case should go. Here in our constitution, no, the minister enjoys oversight responsibilities.
But what does that mean? Because that's the part that I'm grappling to understand in the context. What does that oversight responsibility entail?
The oversight responsibility is briefing the minister. For example, minister must know what is actually happening in the institution. You brief him on we normally prepare a report, and what must be contained in the report is contained in the act. So, for example, that you have made a decision that you are going to prosecute Mr. X. All that you do in that report, you inform the minister that I have considered this evidence and I have decided to prosecute Mr. X. Whether the minister likes that or he does not like that, there's nothing that he can do about it. It is for you to prosecute Mr. X.
Can the minister, because there's certain powers, can the minister tell you how to spend your budget?
Chairperson, that's quite a difficult one, I think the people who are more clued up to talk about the budget issues are those that have got the delegations on how to utilize the budget. But just to comment on that, it's one of the issues that we are battling with as an institution, because what is the word? We have had a situation whereby in the last 3 years, we have not been able to fill in positions of prosecutors, precisely because we're not so much really in control of our own budget. And I'm sure you have heard, we've made reports in Parliament that we don't have money, we have not been able to fill positions, and the fact that we're not able to fill in positions, we have addressed this issue with the DG of Justice, who is our accounting officer. So it's a kind of a difficult question to answer to you, but all I know is that we get we get a budget that we are given, and we can only utilize it in a particular fashion.
And your budget is an allocation from the budget of the Department of Justice.
Yes, Chairperson, it is.
Is it ring-fenced?
It is actually not ring-fenced. I remember in 1 year, and we still have a gripe up until today, that 20 million was taken at a time when there were cost-saving measures, and that money never came back. And we always said that this is the reason why now we're struggling. We can't even have programs of aspirant prosecutor programs. We basically cannot do anything. For the past 3 years, we have not been able to fill in any vacancies in the MPA.
Thank you.
I also traversed with Advocate Nomgcobo, and it's another issue that I've been battling to comprehend its role in it, which is why I'm specifically asking you the question, is the whole issue of public trust and the perceptions of bias, the kinds of negative media coverage that goes with, let's assume, media articles, whether there's truth in it or not, it shapes a public perception and it shapes a public trust in an organization. And how does one counter that? What does one do?
When I attended, recently we hosted the International Association of Prosecutors, which is a body that consists of prosecutors around the world. And that is what we were actually grappling with. Because this is not something which is happening only in South Africa. It is something that is happening also around the world, at least from the discussions that we had with the prosecutors. So we were divided, we divided ourselves amongst groups and all of that. And one of the things that we said was that perhaps we need to put oil in our communication strategies, because sometimes things are said in the media, and as long as we don't come out as the institution that is supposed to respond in those particular things, those perceptions will remain. So one of the strategies then resolutions that we made was that we need to engage the media quite often so that we can be able to educate the media on what is happening. I'll make an example for you, Chairperson, if you don't mind. And one of the issues that we've also discussed this as an institution, particularly, that you get a case which is so discussed in the media such that by the time it gets to us as an NPA, we are supposed to prosecute the case. And yet, when an assessment of the evidence is done on a particular case by a particular prosecutor, there isn't sufficient evidence to put that case and be able to prosecute it. So where do we then fail? We then fail at a stage whereby, at that particular stage, where there is actually that there are emails that are going on, these emails prove this and that, then we are supposed, at least one way or the other, to engage the media and say, whoa, hang on. This is not the process. This is not the process. Let us wait for the police to investigate the case. And once the police have investigated the case, then we can be in a position to say we are now making a decision on that particular case. And I think it's a recognition that we've all made with my colleagues who came from the other countries, that we need to push our communication strategy very well.
Now, I just want to get the chronology of your path, and maybe do it a bit backwards. You assume office as the acting NDPP in December 2011. We've got the dates, the exact dates somewhere, but it's December 2011 that you take office as the acting NDPP, correct?
That is correct.
Right.
It must have been on the 28th of December 2011.
Yeah, that's probably right. I wasn't sure if it was the 28th or the 22nd, but I think you might have been appointed as the DNDPP the year before on the 22nd. It's almost a year later that you get elevated, correct?
2010 is the DNDPP, yes.
Yeah. And you're in the position as the acting NDPP for effectively until September 2013 when Mr. Nksana gets appointed, correct?
I will say up until 2013. I'm not sure about the month, whether it's August or October, but somewhere there in 2013.
But the principle is there, you hold that position until he takes it over.
Yes.
Right. And that's so effectively that's 2 years and whatever bit there is, you act.
It's about
Right.
18 months.
No, it's, yeah, you're right. Oh, that's right. Somewhere in between that, before you take on the job as acting NDPP, you get a point, or before DNDP, the media reports you got appointed as the head of the SIU. And then that was cancelled out later, and Advocate Mohatla gets that job. Do you recall that? Or is it just media hype?
I never really got an official appointment as such to act as a head of SIU. But I do recall that there was such. Yes.
Okay, but you never assumed the position.
No, Chairperson, I never assumed the position. I remember it was called a weekend acting, something to that effect, but it never really took place. I think it was
Did
an
you get
announcement.
a letter or what? Or it was a conversation that you might get this? Because when you say there was such, what's such?
I have also learned from the media, Chairperson, that there was such an appointment to act as a head of SIU. The one appointment that I got to act officially, and I got a phone call, and I got a meeting of that was the acting appointment as an NDPP. Yes.
So you never served as head of the SIU?
No, Chairperson, I never.
And nobody who could inform you that you had that position did so.
No, I was never informed officially that I actually was appointed to act as head of SIU.
Were you asked beforehand whether you would be prepared to take up such an appointment?
Which one?
The SIU one.
No, I was never asked.
Now, during the period December 2010, well, hold on. When you were NDPP, Advocate Mokgoro reported to you, correct? When you were acting NDPP. Based on his proclamation, he would be in the office of the NDPP and he would report to you in the reporting structures.
The special directors, all of them, are in the office of the NDPP, but for purposes of reporting, there would then be a deputy national director who is in charge. But let me just say to you that in 2010, during Advocate Simelani's time, that was the position.
And 2011, during your time?
I think let's rather say 2012, because really, if you look into the dates
2012, yeah.
when I assumed the post, there was just, few days before we could all go on holiday and all of that. So nothing really happened there.
Okay. So let's talk about your stint as a 2012 stint, and Samalani's before that, and Nksana's after that. Okay? His appointment is in the office of the NDPP, and you say that actually in reality he reports to whoever's heading NPS. Is that correct?
He reports to a deputy national director that is heading NSSD.
Remind us again, what is NSSD? It's
It's
Monday Morning Advocate Jiba.
It's a unit essentially that houses all specialized prosecutions. So it would be sexual offenses and community affairs, and then it would also be priority crimes litigation unit, and then it would then be the special commercial crimes unit. So, yeah.
Okay. And during the period that you are deputy NDPP, and when you're acting NDPP, you're not suspended and you're not placed on special leave. I'm talking about the initial period in 2011 and the period in 2012. Correct?
Yes, I was not suspended.
So I know there's a difference in terminology between suspension and special leave. That occurs after Mr. Nksana comes in, that you go on special leave. Correct?
No, it actually occurs during Advocate Sean Abrams' era. That was after the judgment of the GCB in Lekhodi's, in Judge Lekhodi's case.
Right. And so that's the one period that you go on, shall we call it special leave? Because it wasn't really a suspension. You wrote a letter and you went on leave. It was appropriate because there was a judgment with the finding, right? Now let's go a little bit back. In 2007, when the issue arises about the affidavit which you provided to SABC, you are also placed on either a suspension or a special leave. And am I correct that that's a much longer period of time? That's roughly from, well, you tell me, when was it? Can you recall? January 2009, something like 20 months? Could it have been that long?
Although I wouldn't be sure of the period, but it's around about that time. I wouldn't be sure of the real period of suspension as to how it lasted, when it lasted.
And it's not long after you return and you come back after that period of suspension, when the settlement is reached, that you then go to the SEC unit, correct?
Yes, after my suspension, I chose to go to the SCCU because in terms of the settlement, I was supposed to report to the DPP office. Then I made their request. I'm not so comfortable with doing rape cases and murder cases and all of that. Yes.
So then you go into the office with Glennis Breitenbach, right?
Yes.
Okay. Now, I'm going to come back to that whole issue, but I want to talk to you firstly about the Boyson matter. And I want to say that I'm asking you these questions not in the context of any determination as to whether anybody is guilty or innocent. That is for a court, once the matter comes to trial, to determine, be it in the murder charges or be it in anything on the charge sheet. So I'm not asking you the questions from a presumption that anybody should be exonerated outside of a court of law. And I think we are all in agreement that the criminal justice system has run its course. That's not the context of it, right? But as I understand, and I'm going to call it a narrative that has developed in the Boyson, it's not matter, let's call it matter, is the following, and it is let's separate the murder and other charges in the charge sheet from the racketeering charge, because you would not have made a decision in respect of the other charges. You solely they come to you about racketeering. You agree?
Yes, Chairperson.
Right. And so the narrative that develops is that these charges are brought against him for some ulterior, almost nefarious purpose to remove him from criminal investigations which he is conducting, overseeing at the time in KZN in his capacity, and the effect of that is that those investigations or steps that he've taken are impeded by him being implicated in a racketeering charge. And he couples that with what is perceived to be steps which is then taken against Simpiwe Molochwa to remove him as the acting DPP in the KZN, and they link this up and they say, well, this is the scenario which shows that the only answer that could be behind the decision taken on racketeering is that you must have made an improper decision. Do you think that is I'm summing up what is a public domain narrative. I'm not putting it any higher than a narrative that emanated from Mr. Boyson's evidence and from what is in the public domain. Do you understand that that is what is being said?
I do understand that that is what is being said. But I have explained during my evidence in chief the nature of the evidence that was presented before me that led me into instituting a prosecution in terms of Section 2. So I can tell you right now, and I can promise you, Chairperson, that that narrative is extremely false. I did not know General Boyson at all. I was quite surprised, you know. If you saw us the other day after his testimony, we were standing right there together. We discovered that we belong in the same church. So I did not know him at all. Even if I did know him, I would never, from the oath of office that I have taken, make a decision to prosecute anybody because of any other reason except for the evidence that is contained in a particular police docket that is presented to me.
All I can say is one or other of you are not going to church often enough, but let me explore that with you for a moment. Let's put the narrative to a side and let's look at providing, let's talk about what was before you. Now, I'm no expert on racketeering, so feel free to correct me if I put this wrongly to you. But it seems as if from the evidence in direct that you gave, it is probably one of the most serious offences or the most serious penalties in our laws. Would you agree with that?
Yes, I do.
I mean, short of death penalty, it seems to be quite a serious offence. And the legislature, aware of that, won't allow people to be charged with that offence unless the highest office in the prosecuting service has authorized it. And it's because it's such a serious sentence attached to it that they have grave implications. That's why it comes to the NDPP. Would that be what was the thinking behind it?
I suppose so, Chairperson.
And it seems from, and we can disagree about whether there's a committee or a team in place or whatever, but it does seem that what is required from within the NPA system is that there be a proper process put in place to make sure that when racketeering decisions are taken, that the I's are dotted and the T's are crossed, as a matter of principle. Would you agree with that?
Indeed, there is such a process that is put in place in the NPA. I agree with you.
And so whatever evidence serves before an NDPP when the decision is made must show a prima facie case of racketeering. Do you agree?
I do agree with you.
And so what I want to explore with you a little bit, because I'm not clear on it, and I'm not sure it was quite clear from your direct evidence, is the information that was before you that indicated what Mr. Boyson knew or ought to have known about the enterprise in the Cato Manor unit that was is alleged to have been operated. And so that's where I want to take the questioning to you now. Now, you would have had to have had evidence implicating him in leading the enterprise. Correct?
I don't think we should say in leading the enterprise. The provisions of Section 21F, they speak about managing the enterprise, taking control of its activities. That's what the provisions speak about, yes.
You're quite correct. I'm paraphrasing it badly. And what you had in your possession to show you that, and for a moment put aside this debate about whether it's hearsay evidence or not, because it seems as if the Act makes provision for you to have that kind of evidence. So I'm not quibbling about the type of evidence you have, right? But it does seem that what showed you, or what is purported to be, because I'm choosing my words very carefully because I don't want to be interpreted as having predetermined whether evidence is good or bad, so bear with me with that. But that which shows his management and control of this enterprise is the statements of Mr. Aya and Mr. Danikas. And that was put up to show that, because they don't actually relate to anybody else in the crime, in the charge sheet. Am I interpreting that correctly?
That which showed that he has taken over the functions of controlling and directing and managing the serious violent crime unit of in Katomano is the evidence of Colonel Aya, together with the reports then that would also be submitted to him. Yes.
What do you mean the reports? Let's just be very specific about what reports we're talking about, because there's many dockets in this matter and I don't want to confuse what you're talking about.
The reports of the operations, for example. For lack of a better word, I don't want to say the reports of the killings. I want to move away from this word killing and say the report of the operations that have then been conducted by the members of the Katomano unit, yes, that have been charged, yes.
And so the reports that's generated in the Katomano unit is then given to Mr. Boyson. Is that what you're saying? And that is an indicator that he's controlling / managing.
I'm saying that the statement of Aya, when you read it, it tells you exactly how General Poison took over. You must remember the police, they are structured like ourselves. If you hold this position, you must hold that position. So the essence of the evidence of Colonel Aya is to the effect that he became redundant, whether by virtue of him being incompetent, or whether by virtue of him, by virtue of office politics, as General Poison has placed it. For me and for the prosecution team, all that we had to show that is that exactly because of that, you then took control of that particular unit.
As I understand, what he's saying is that the information which was at your disposal didn't allow you to make it fall into either the subcategory E and F, which is 2E and F, because it didn't show that he was the direct supervisor of the unit or that he instructed him or managed him. And that's why he says there wasn't a link. And as I understand your evidence, you say, no, that's not correct, because what I had before me was the statement of Aya, which does show that link. Am I understanding it correctly?
You're correct, Chairperson. That's why I'm saying probably that is the basis of his defense, that he must say elsewhere. And I'm sure further evidence could be laid. You know, when you are conducting a criminal case, you don't really rely on one statement. There are also other factors that actually come into play. So as I'm saying that probably that is his defense, that he's entitled by all means to lead before a court of law. But you are correct where you say that that is the basis.
Now, one of the other things which is raised is this whole issue about inquests, whether they're formal inquest or informal inquest. And I'm not for a moment suggesting that an inquest precludes criminal proceedings, because I don't understand that to be the role of an inquest under the Inquest Act. But one of the things he raises is that there were a number of inquests that were held in respect of some of the people who had been killed, and that those inquests were closed without making any finding against the police. And I understood the point he sought to be making was, well, you looking for something?
Yes, I'm looking for some, but you can proceed. I'm
No,
listening
no.
to you.
No. I'll take a minute and find it. It's fine.
Thank you. You can proceed. Advocate Bao.
Sorry. So what I understood him to be saying was, if the magistrate ruled, and I think it was 4 or 5 of the cases, not more than those. I stand corrected, but I seem to think that it was 4 or 5. If the magistrate finds that the shootings were justifiable, how can it be said that I should reasonably have known that these were unlawful shootings? And so I want to know from you, how did you accommodate the fact that there were these inquests in taking into account? Because those killings form part of what's on the charge sheet.
You're quite correct, Chairperson, that it was important that we establish that he reasonably ought to have known. The reasonableness of his knowledge. Remember when I testified here on Chief, I made an example. I referred to a particular case of a Mr. Elfias Mkhize. Mr. Elfias Mkhize, who was a member also of the KwaMaphumulo Taxi Association, had, because of information that they had received from one of the members who had been arrested then, that member, after he was released, he then informed them that the police have said they are going to kill them. And indeed, Mr. Elfias Mkhize instructed Hlopane or attorneys, some attorneys in KZN. And the attorney who dealt with the matter was a Mr. Shezi or Mr. Shozi. And letters were then returned to the police, to say that in the event that there is anything that you have against our clients, please let us know. They should be afforded their legal rights and all of that. And one of the responses was made by General Boysen himself in those letters. And when the application was made before court in KZN, he was one of the respondents. In fact, was respondent number 4. And he then responded. It is in his responses that he then gave, basically, that he knew, because he was responding about how these things have occurred and all of that. Yes.
So can I tell you that I have had great difficulty in trying to get my mind around that interdict application. I have never heard of a scenario where somebody goes to court to get an interdict to stop what is an obvious unlawful activity, and a court actually grants it, because at the end of the day, it is with respect to the applicants and what transpired, a somewhat nonsensical application to have brought, because what are you going to hold them to account for? They breached the interdict by actually doing the unlawful killing, but it seems to have been an application which doesn't seem to have been founded on a rational legal basis. Do you have a comment on that? How do you get an interdict of that nature?
I think it's a difficult question to answer, because I'm not sitting here I don't know what went on really.
Let me withdraw it. It's not a fair
in the
question.
mind of the judge. But
It's not a fair
okay.
question to be asking you. Let me withdraw it. It just seemed to be I know that. My junior is trying to find that affidavit. I want to come back to that. In addition to the issue of the inquest, where the inquest had found that certain shootings, they couldn't find any unjustifiable shootings on the part of police. There also seemed to have been some sort of evidence in respect of some of the deceased that they had positive primer residue on their hands. Do you recall that?
Except for what you say about the inquest. Let me just deal with the inquest. It really depends on what evidence was presented before the magistrates with regard to that particular inquest. I do remember for a fact that there was, in one inquest that I can recall, where a magistrate had recommended that some police officials should be held responsible for the death of one of the deceased person. I think it was a death in escort, basically. 2, there were ballistic reports that did an analysis of the shooting, as it were. And you know that with regard to murder cases, there's a lot of reliance which is placed on ballistic report because they are experts. So all of that evidence certainly disproved any any sense of self-defense. And also there were statements of witnesses who witnessed how their partners or then husbands were killed. Yes.
I accept all of that because I think all of that is evidence in the murder matters. But I was talking about when you look at the pattern of racketeering that included in those cases were cases where a magistrate had found the shooting to be justifiable, and there were cases in which the ballistic report showed that in respect of some of the accused, there was a positive primary residue on the accused, and in fact, my junior reminds me that that was also the case in respect of Mr. Mkizwe. That the ballistic report showed that there was a positive primary residue on his hands. I don't actually recall whether he was one of the subject matters of an inquest, but certainly there was that. So my question to you is essentially what role do you play in determining this pattern of racketeering when in some of the instances there is some indication that there is a positive primary residue on the hands of the accused, the deceased?
That's exactly the point, Chairperson. There's two sides to this. There's two sides to it. There's one which I have said in my chief is that it is a defense that is provided for by the members who have now been charged. Ne? And I said there, having looked into what is defined as pattern of racketeering activity, which constituted an ongoing, from where I said, execution of, for lack of a better word, executing these operations, essentially. So that constituted a plan, because if you look into this, if you look into the matters, if you have the charge sheet before you, you look into the matters, it's really a plan. It is something which is happening repeatedly and continuously. And of the people who are claiming to have been attacked, none of them has had a bullet that at least has struck him. All of them, none of them were struck by any bullets in the claim of. So I felt that it is then a court of law that must make a determination whether indeed they were acting on self-defense on the basis of what we are going to present before court, or whether they exceeded these bounds of self-defense. And that is where, yes.
And that is for a court to determine in relation to the murder and those kinds of charges. My question was a slightly different one in the context of racketeering, because if you're looking at a pattern of racketeering, then surely the role and the presence of the inquest findings and the positive primary residue is a different consideration that you take into account when you look at that pattern. So my question maybe to ask you straight is it your position that you took that into account and you nonetheless came to the conclusion that it still constituted a pattern of racketeering?
What constituted a pattern of racketeering are all those predicate offenses that are referred to in the charge sheet. Everybody in the racketeering offense has got a role that he particularly plays. It is not necessary that as a manager, as we call General Poison a manager of that enterprise, if you're charging in terms of Section 21F, it's not necessary for him to be at the scene at all. There's no necessity for that. As long as he ought to have known that his members are doing such activities, and that is what we say we have evidence to prove.
Now, in your affidavit, you make the statement in paragraph 16.6. Maybe I must tell Mr. Mokgoro to take you there so that we don't. It's folder G, paragraph 5.1, and it's 5.1.31. Right. And you will see it on paragraph electronic page 7. Mr. Mokgoro, just tell me if you battle to find the page. Paragraph 16.6, it's the record page 133, and he's become a Dropbox fundi. And so my question to you is essentially, what was the information under oath to which you're referring to, which indicated to you that he knew or ought to have known that they were killing suspects?
It is the affidavit of General Boysen himself when he responded to the Mkhize matter.
And anything else that you can recall?
I suppose also the reports that Colonel Aya was referring to, and basically also his own involvement in the killing of one of the deceased person, but though that was not a statement that was made by Anna Oath. Primarily, it was the affidavit that he made in the matter.
You then go on and you say the information further revealed in the next paragraph that unlawful activities of killing suspects and our civilians were in certain instances motivated by the applicant and member of his unit's desire to enrich themselves by means of state monetary awards and or certificates of excellent performance. And you then attach, in that respect, the submission that was made to the Police Provincial Department, which would be the next document in the line, which is 5.1.32, where you actually see at page 1 the submission that was made on the 14th of October 2008 for a monetary award or a non-monetary award. Now, I'm not sure if I misunderstood your direct evidence. It is signed by the Provincial Commissioner, so it's not self-motivated. Do you see that? Mr. Mokgoro, are you looking for a hard copy? Because it's just the next document in the Dropbox 5.1.32. So if you just scroll down, it would be the first page. And if you scroll down to page 318, you see that it's signed by the Provincial Head Detective Service, KZN.
Yes, what I was being asked by the chairperson is whether when you make these requests for performance
awards.
awards,
Yeah.
do you do it by yourself? And I explained that in my environment, that is actually what happens. You do it by yourself.
Okay, so I understood General Boyson's evidence to be that you get nominated, it gets sent up to a provincial commissioner, your name then gets put forward, there's then a committee at national level that makes a decision, and as I recall from another life, SAPS then has a huge award ceremony at some point in the year, and the higher echelons in SAPS then makes a call as to who gets the awards. You don't take issue with that?
I don't take issue with that, but the provincial commissioner will not necessarily know about the reasons why you qualify for this particular award unless you have told him or you have made some form of a particular report. Like I get reports they get written by a prosecutor sitting at Kwazakele, and then an SPP writes his own summary of the report, and then it goes to a particular DPP. By the time it gets to head office, it is a report now that is compiled by a DPP on the basis of all information which has then been submitted through all the areas.
That's your environment. The evidence that General Boyson gave us here is essentially that he got nominated and he didn't add anything to the motivation, as I understood his evidence. Remember, we're having this discussion outside the context of what was proven at the criminal trial. So I'm simply putting to you what he's said to us at the time. Was there anything before you that either way decided whether Mr. Boyson did it himself or whether he was nominated in the process?
This document, if you read it, it says what was his role, and I'm saying there is no way that your role will be known by your provincial without you having indicated what your role is. So if you're asking me, why did I consider this evidence? I considered this evidence along with other evidence.
No, that's not my question. We can accept that somebody else could have written down his role in this document, and I don't understand him to be disputing that what's contained in this document is an accurate reflection of what his role was. I think what he was trying to say to us was that he didn't compile this document. Somebody else nominated him for the process, and that's what he did. Your point is the facts are the facts as reflected on this document, and that's what I took into account. Am I understanding you correct?
That is correct, Chairperson.
And that effectively what this document shows is a factual account of all the steps that they had taken to follow up leads in respect of finding the person who had assassinated one of the police officers, and the steps and that his only involvement was providing the information related to a car chase which resulted in the person in the car being killed, as I recall. Correct?
That is what he said.
Now, in fact, that's what the document says on the face of it.
On the face of it, that's what it says.
And effectively you read into that he was actually being without any suggestion being made by him to give an instruction to shoot, all you have to do for racketeering purposes is to show control and management. And this was another element in which, or another bit of evidence which showed you that. Am I understanding that correct?
It's showing his element of his own involvement as well.
But one would expect him to be involved, wouldn't you? Because this is SAPS, and when they chase criminals, one would expect people to be involved in that process, in the ordinary course of their duties. And if he got certain information of a criminal going away, he would have had some duty as a police officer to share that information in the ordinary course of his employment.
I agree with you, Chairperson, that he had a duty to share the information. The point that one is trying to make is the fact that he cannot say he did not know. That's just the point I'm trying to make, that he cannot claim that he did not know. This was not just the first killing. The pattern of these police officials, when they do enforce the law in terms of bringing the suspects before the court, it is not what is expected from the South African police. That is just all that I'm saying. And as the prosecution team, I want to make it clear, we should never be heard to be saying that we condone the killing of our police officials. We don't. All that we are saying is that whoever has broken the law must be brought before court through the normal processes. Yes.
Can I just ask, just to get it clear in my mind, would you recall who the police commissioner was at the time?
The police,
Police commissioner?
as in the
National.
National
Yeah.
Commission.
If you don't worry, I'll find the information. Okay.
I
Yeah.
don't
All
recall.
right.
I don't recall.
Thank you.
Chairperson.
I'll find the information. Thank you.
I seem to think it could have been Makanazi, but I'm not entirely sure.
At the national level, Mkwanas? I don't think so,
Could be
yeah.
wrong.
Okay, thank you. Don't worry. I'll find it.
The units,
At what points, Chair, at the time of the killings?
Boys, and when you made the decision and you're talking about the killings by the police,
Or when
You
I
know,
made the decision?
yeah,
I
around
think
that time.
I think it was General Pierre. It must have been, is it General Pierre?
Don't
No,
worry.
when I made
we'll
the
find
decision.
The information, yeah. It's something objective that can
Okay.
be done
Okay.
objectively. Thank you.
the financial reward, even though we're looking at this document, isn't part of what makes up your decision, because at the end of the day, there's no certainty that they could have done this in furtherance of getting a financial reward, because there's no way of knowing whether they're going to get it at the end of the day. So that's why you're not under one of the other sections of racketeering, you're under ENF. It's not the act of racketeering for purposes of getting financial gain.
No. You don't have to conduct, and the objectives of the enterprise are separated from getting a financial gain. What is required is just a common goal and undertaking and commitment, and that we have roles, different roles that you play.
Now, the immediate superior of the Cato Manor team that's involved in this was a Mr. Olivier, which sort of interposed himself in terms of the SAPS ranks between the Cato Manor group and General Boyson. Did you have a statement from him?
He's one of those that are charged. So I don't know whether there was a warning statement which was obtained from him. I'm really not sure, but he's one of those who are charged also under Section 21F and 21E.
instrumental part that he plays in the crimes is the account that's given in this document. That's what you relied on, correct? The information he gives them as to where the vehicle is, what route the vehicle is going, where the accused could be found.
I'm not following your question. If you can
So,
repeat it.
in your affidavit, you make particular reference to statements of Aya, Danikas, and Londo. And then you say from which it is apparent that the applicant is well aware of the information that the respondent have in their possession relating to the murder of at least 28 people. And then you go further and you say the monetary and non-monetary awards claimed by him for the instrumental part he played in these crimes. And I'm sorry, I should probably give you the paragraph reference. It's paragraph 234. No. Is that right?
Where are we reading? Where are we reading for now?
I'm reading from your affidavit in the paragraph 17, which is the next paragraph of where we were early on. And I'm saying to you that the information which he provided to the Cato Manor squad is the instrumental part that he played in the crimes, which is evident from this document. That's what you sought to be saying.
Why am I not following you, Chairperson?
Okay.
Maybe you must simplify it.
Yeah, this racketeering thing is not easy. In paragraph 17 of your affidavit, you say there are statements of Aya, Danikas, and Londo. They say that he is aware of the murders of the 28 people. That's how I read the paragraph. And then you go on and you say the monetary and non-monetary awards claimed by him for the instrumental part he played in these crimes. Now, the only instrumental part that one sees from the awards is the information he imparts to the Cato Manor squad as to where to find the person before the car chase ensues and which direction he's going before he gets there. That is what one sees from the award. So I'm confirming with you that is what you are referring to when you talk about an instrumental part he played. Over and above what he reasonably should have had knowledge about, he was also instrumental in one of the events.
You know,
Sorry,
Yes.
I'm so sorry. You asked a question about Olifir, but you're now talking about poison. Am I correct? So that I don't get myself thoroughly confused. Because the question was, with respect to Olifir, the information would be the reward documentation.
Sorry, I didn't link Olivia to the reward documentation.
No, sorry, but what was the question in respect to
The
Olifir?
question was that there's a hierarchy, and the immediate superior to the Cato Manor group was Olivia.
And then she says
That he is
Olifir
also
is
charged.
And then you then talked about the document. So you were not linking Olifir to the
No,
document.
I had
Oh,
forgotten
see.
about Olivia, and my
Oh,
junior
okay.
reminded me that I hadn't asked the question earlier.
Oh,
So I just
so you went back to it.
so I went back to it. Sorry.
Sorry, maybe you should repeat the question because I disturbed her. I just didn't understand the link.
Sorry, are you understanding my question now? The role, you use the word instrumental, but the role he plays, which is evident from the monetary awards document, is that he provides the information to find the person who is killed.
if we restrict to the monetary award, the role he plays in that particular regard, that's what it is meant.
And the other affidavits show that he had knowledge together with the monetary award, which shows him that he has knowledge.
the evidence considered as a whole shows that he had knowledge. As I indicated to you, if you read my affidavit from paragraph 16, and not just read particular paragraphs, you must read it in context from paragraph 16. In paragraph 16, I explained exactly what I then had before me that I actually considered. Then this is now towards the end, in conclusion, just making particular statements, but without ignoring what I've said in the preceding paragraphs.
I accept that because in paragraph 16, you set out in detail what you did have regard to, right? Now, what you don't say is what you considered, that you considered the dockets. And if you look at paragraph 21 of your affidavit, you say, these are some of the instances that are referred to in the above-mentioned statements, which were considered together with the other information in the docket before the impugned decisions were made. And you don't then, in this affidavit, I do not intend to detail all the information that was placed before me prior to making the decisions in question. And I just want to be clear, you are saying that the dockets were before you as well.
When the matter was presented, you must understand this docket is huge. I'm sure you've seen it. There's no way that they could have brought all of those dockets before me. But what then happens is that when you are getting a presentation, you want to know, you want to see, where is this one? And that is how I then got to see what was then, what convinced me, essentially, is what I then requested as presentations were being done. So if your question is that I read all the docket, I could not have read all of that docket. I required just information sufficient enough to enable me to make that particular decision. Yes.
What they then did was, when the application from Mr. Boyson came, the team put together an internal memorandum for the council. Were you party to preparing that internal memorandum, or did the prosecution team do that?
I won't be able to remember now, Chairperson. You know, I've been involved in so many litigations, so it's kind of difficult to remember for me where I was part of and where I was not part of, unless I have to go to my affidavit, because at the time, maybe I made the affidavit, the things were still fresh in my memory.
It's not clear, but let me take you to the document. It's 5.3.20 in that folder of 5.3. And what the team details is essentially what they put before you at the time. 5.3.20, and I'm on page 2 of the document. And what they did was, as I understand it, they prepared a ad seriatim response for counsel in this matter. And then in response to paragraph 50, are you with me? Folder G, number 5, 5.3, 5.320. Right. And I'm on page 2. Right. And it's a response to what they say the evidence was that they put before you. They put evidence before you that he was the de facto commander of the Cato Manor unit, which shows you your management and control, the monetary awards, the statements of witnesses which incriminated him, which is Nondlo, Aya, and Danikas, and his answering affidavit. Do you see that? And those were the main documents on which you relied for purposes of reaching your conclusion.
In respect of General Boyson, mainly.
Yes. Let's talk only about general poison, because fairly this review application only dealt with general poison. You would have looked at other stuff for other accused.
But in my affidavit, we referred to it as the Mkhize kind of an application. It's called the Mkhize application. So I think it was, for lack of a better word, when they actually pointed only to the affidavit, because remember, the response to the affidavit itself is in one singular file. So it's called the Mkhize affidavit. So if you read my affidavit, it will refer to that.
Yes. And you say you consider that with other information in the dockets, which you do say in your affidavit.
Yes, Chairperson.
And you don't take issue with what Boyson says when he says, when you look at the docket, I'm only mentioned by name in 2 of the 23 dockets, and only 3 of the 290 odd statements, be that Naidu, Cochrane and Williams, place me at the scene of the crime or implicate me in the crime. Because you're saying to me, for purposes of racketeering, that doesn't matter. Do I understand you correct?
It doesn't matter indeed for purposes of racketeering. If you are not at the scene, just like the drug masters, they're not at the scene of the crime selling drugs. You get people selling drugs, but the mastermind is sitting somewhere in Summerstrand.
Now, the photos, I looked at that a considerable period of time, and I just want to be clear that we don't misunderstand it, and they are horrific, and they must be even worse if, as a seasoned prosecutor, you regarded them to be gruesome. But I mean, I personally thought they were horrific. And like you, I would not want those families whose relatives have died in that manner for those photos to be splashed all over the media or in front of an inquiry. As is, it's going to end up going before a trial court. But what I could not get the link to is what was the relevance to the photographs to a decision on racketeering. And I want you to understand that I'm raising this because I don't want it to be misunderstood that the more gruesome the crime, the more one likely is able to conclude that there's racketeering, or that one is swayed by the photographs. So I can't quite see where the photos fit into the question of holding somebody accountable for racketeering. Do you have any comment on that?
It is the analysis by the ballistics experts that becomes relevant as far as the photos are concerned. If I can refer to the ballistics analysis of a particular expert that I can't remember his name now because there were others, there were many ballistics that acted. Yeah? In the case, for example, of Mr. Mkhize, he says that there is no way that there were any bullets that came from his motor vehicle. Part of the reason is that when he was shot at close range, and then he has drawn some pictures in there, and he refers it as a rain of what is it called? Bullets, yes, yes. And because of the manner in which the window appears to be, there are no bullets that came out of that particular when he was driving the car. So there are no bullets that came in out of that because of the manner in which the window appears from the photos. The window, the glass of the window, there's no indication that it has ever been opened, except for the fact that the openings that you see there are caused by the rain of bullets. Number two, there were no cartridges that were linked to the alleged firearm that was then found in the car. There were no cartridges that came in there from that particular firearm. So the importance, and then they analyze that if the bullet comes in from this side and it goes in from the other side, it means this and that and that. So that is actually the relevance of the photos, yes.
And do they have an explanation? Because I recall that report actually. And I couldn't recall whether there was an explanation as to how the positive primer residue got into his hands. Because there wasn't an indication that the gun was fired.
I don't recall that. I don't recall myself, Chair, really. But all I'm trying to say was to explain the relevance of these particular photos.
I want to take you to, in that same folder, 5.3.21, which is the memorandum which is then given to advocate holders from the team after the replying affidavit is filed.
Ms. Bauer, are you done with your cross regarding the pictures? Okay. Can we take a break now before you do the next part? Because the technicians need a break. 10 minutes? Thank you. Thank you. Ms. Bauer?
Advocate Jiba, you've got the Mkhize, the affidavit by General Boyson in the Mkhize matter. Can you tell me if there's anything specific in the affidavit which you relied on, or was it the fact that he had the knowledge per se of what's contained in the affidavit?
The responses that are given by General Boyson in this affidavit have got to be taken in the context of all the evidence. Okay? The evidence, as I've said, is that before this application was launched, in particular before court, certain correspondence was addressed to the police. It was addressed to, I can't remember who, but part of the response, one of the letters was responded to by him, essentially. So when you read the response to the affidavit, you then read in the context of the fact that he has been aware of the issues relating to the operations and in the manner of the operations that were conducted by the people that were under his control. So when you refer to this affidavit, you refer to it in that context, that it then shows that he knew of what was happening. Yes.
But wouldn't you expect the head of the organized crime unit to know what's going on by virtue of the fact that he's got that position? If a court application is launched, that he looks at the files and is able to deal with the allegations? I'm simply asking the question because it does seem that's what generally happens when somebody has to depose to affidavits. They look at the files, they make the affidavit. Let's test this. Let's assume this affidavit was signed by the third respondent, the SABC Provincial Commissioner KZN. Would you have taken the same attitude towards him and say, well, given the contents of this affidavit, you also part of the pattern of racketeering?
With respect, Chairperson, I think I've answered this question of why I made this decision that he knew. I've even testified about it on oath. When I was here on Friday, I have explained it in as much as that is how far I could take it. So I do not want to run into some presuppositions that what would have happened, because perhaps the facts would be different or the facts would be the same.
Let me move off this, Advocate Jiba. Advocate Moloshwa came to give evidence, and your evidence was that you had informed him that there is a case, that you had made a decision that that case will be prosecuted, and it will be done by prosecutors not from his division for various reasons. Did you provide him with those reasons?
Yes, Chairperson.
And what were those reasons?
The reasons were fairly simple. That the police, I think they were from IPID, they were raising concerns about the fact that this case was not being done, and there were suspicions about the manner in which the Katomano police were held in such high esteem in KZN. And in fact, Chairperson, that got confirmed, because at some point in time, there was an article that where a judge was actually also attesting to the beautiful work and exceptional work that was being done by this Katumano police. So it was really founded just on those issues, and I never wanted to cast aspersions on on the prosecutors in KZN. But all I wanted to ensure was that, for what it is worth, let's get other people to get involved with the case.
So, when Advocate Molochwa testifies, he didn't ask for these other prosecutors to come to KZN. You sent these other prosecutors to KZN, is correct?
He's correct. He never asked for prosecutors to go to KZN. It was a decision that I made. And to my memory, that was not a decision that he objected to.
Now, he went through this email exchange between him and Advocate Chauke on the 12th, 13th of June. Do you recall this email exchange where they have a bit of a spat about him signing the indictment and him not signing the indictment? Shall I take you to it? I think it's J90.
I do recall it when it was produced here in the inquiry.
It's attached to his affidavit, and essentially you are included in.
Yes, I am copied in the email. So I'm saying I do recall that he referred to that particular email.
Right. And essentially, he is effectively refusing to sign the indictment unless he's provided with the underlying documentation. That's the nub of the spat he's having with Advocate Chauke, correct?
That's a spat they are having with Advocate Chauke. That is correct.
Do you intervene in the spat at all?
You know, Chairperson, if I were to intervene in all the differences that those DPPs have, we would miss the point of why we are here. They argue about many things. I remember in one meeting when Advocate Smelane was still our NDPP, he used to say, today there's going to be blood on the floor. Because each and every DPP feels strongly about this particular view. So it is in those circumstances where you really come. You must then come and then raise the issue, and that is really the time when we'll say, oh, okay, let us try and resolve the impasse that is actually between the two of you. Otherwise, under normal circumstances, they are able to resolve these things amongst themselves. And you will think that when you are in a meeting, they will never speak to each other. But by the time you get out of the meeting, they're calling themselves my chief, my chief, my chief.
Advocate Jiba, you appointed Advocate Chauke to oversee this prosecution. You appointed him to oversee a prosecution that was in the jurisdiction of Advocate Molochwa. Advocate Molochwa essentially is accusing Advocate Chauke of some sort of impropriety by expecting him to sign an indictment without underlying documentation. And you don't get involved.
In the first place, I couldn't understand why Advocate Chauke is asking Advocate Molochwa to sign any indictment. Advocate Molochwa had no responsibility to sign any particular indictment because indictments are signed by deputies. But as you go down the email, Chairperson, they then resolve the issues amongst themselves. Indictments in the organization are signed by deputies, and there were deputies that were supposed to sign that particular indictment. Indictment is just an ordinary charge sheet.
They don't resolve it. What they do is Advocate Chauke withdraws the request from Advocate Molochwa at that juncture. In fact, as I understand it, it only gets signed by Advocate Olochwa's substitute when she comes into office. Is that not so?
Oh, you are confusing the indictment and the application for authorization.
Okay.
Those are two issues. The indictment was merely an indictment to indict the particular accused person to appear on some predicate offenses. That is why I'm saying I just could not understand what was this all about, because at the end of the day, indictments are signed by deputy directors, which is why there were deputy directors in that team.
Okay. And so ultimately one of the deputy directors signed the indictment.
I believe so. I don't know whether it was Advocate Matenjo or Advocate Mayema, but one of them.
But one of them signed it. Right. Now, you got into a difference of opinion with Advocate Hofmeyer about how the unit operated when it came to racketeering. And attached to that, is it not so? Whether we call it a team or whether we call it a committee, in the NDPP office was a special projects division of which Advocate Mozing was part of. Organized crime projects or something like that. Correct?
He was not just part of, he was a head of it, because he was then a senior deputy director.
Right.
Below him, there were senior advocates. One of them was Advocate Mamabolo, and the other was Advocate Kruger, who then resigned some time ago. And there were many other senior advocates and junior advocates that were then below him.
And generally when people came and they brought racketeering applications, they would go to that organized crime special projects division to have a look at it, to prepare whatever the documents that needs to be prepared for purposes of the NDPP. Whether you go to Advocate Mamabola or whether you go to Advocate Mozing or whether you go to Advocate Kruger.
No, it is not whether you go to Advocate Mamabolo or whether you go to Advocate Kruger. It goes to the person who's the head, and that person who's the head assigns responsibilities. He then says, you must deal with this one, you must deal with this one, according to their level of experience. So it doesn't come addressed to a particular advocate, for example.
So if you look and Advocate Mr. If you look at folder M number 14, which is Willie Hofmeyer's affidavits, and you go to 14.8, you'll see the annexures to his affidavit. There's a memorandum on page 32, the last 3 pages is a memorandum which is prepared by Advocate Mamabolo. And essentially it is correct because he doesn't have anything to do with the Boyson matter. Are you there, Mr. Majabu? Folder M, number 14 is Willie Hofmeyer's, and then the one is his annexures.
Is it the one dated the 6th of March?
It is the one, no, it is the one dated the 25th of January, 14.8. It is the annexures of the affidavit, not the actual affidavit itself.
January.
Yeah, but not the affidavit, the annexures number 14.8. Do you see that?
All I see is an email which refers to an attached memo, but there's no memo attached. The next memo that is here is the one dated the 6th of March.
Go to the last 3 pages of that document.
The one dated 6 March.
The one dated, uh, yes, it's dated 6 March. You got it?
Yes, you set a different date.
And he effectively gives us an affidavit where he tells us that Advocate Mosing comes in to head the unit. Do you agree with that? You appointed Advocate Mosing to head the unit,
Yes, Chairperson?
right? And that the procedure that used to be put in place was that 2 of them in the Special Projects Division would deal with authorizations of prosecutors for racketeering charges. And when it dealt with certain ones like the Savoy matter, the Boyson matter, those would be dealt by Advocate Mosing. Correct?
What is correct?
That Advocate Mosing dealt with the Boyson matter.
Yes, he dealt with the poison matter.
Right. And did you still have a system in place where you required 2 of them from the special projects, from that unit, to look at racketeering applications, or was it left to them to make that call?
It was really left up to them to make that call as to how many would be involved in a particular case.
So if Advocate Mosing dealt with it by himself, then that was Advocate Mosing's call.
Yes.
Right. Now, if we go back to IPID came to see you and you set up this team. IPID came to see you in March and you set up this team of prosecutors relatively quickly after that. Correct?
That's possible, yes.
Right. The conversation that Advocate Molochwa says he had with you, he says he had with you in January, was that before IPID came to see you or after? I'm just trying to place the time period. Because if one looks at Advocate Molochwa's affidavit, and let me refresh your memory, he indicated that he received this call from you while he was driving. He informed me that there was a matter where pressure was being put on you and it needed to be enrolled quickly. And that she was going to call him later. She didn't call you, but that he was then later called by Advocate Chowki, and that they were going to discuss it at the meeting of the 29th of May. You don't take issue with that, except for the fact that you deny having told him that there was pressure.
I think Advocate Molochwa corrected himself about the January. He produced the black books. And he says that the call must have been in March, because in January there was no meeting that had taken place by then with the iPad people.
I think, but we can check the record on that. I thought that do you recall having this conversation with him in March?
I do recall having a conversation with Advocate Molochwa, not about pressure, about just the case, the details of which I could not have given him the detail of what the case was about and all of that over the phone, which is why, I don't know in which Dropbox it is, which is why sometime in March, immediately thereafter, I wrote to the DPP of Northwest. I think I must have written to the DPPs where I was requesting the team of prosecutors.
Okay. Can I say that he corrected himself in his evidence? My junior tells you when I go through my black books, I was able to establish that the trips I made to Port Shepstone are two. One on 9 January and the second on 1st of March. So to cut a long story short, and this was one of the long stories he did cut short. It is my firm view that the day of the receipt of that call was either 9 January or 1 March. But what I can stick my neck out for, it was one of the days of Port Shepstone. So it could have been either one of those 2 days. Yeah.
Okay.
So, in doing that, sorry, I interrupted you, Advocate Jiba. You were saying, so there was a meeting that was then held at the head office at which he attended in your office with a meeting with you and Advocate Chowki, correct?
That meeting now is happening not in March, no? It's happening at some time.
Yeah.
Yes.
And he put that date as the 29th of May because he goes up to the head office for another meeting that is occurring at that stage.
I wouldn't dispute that when it was. I wouldn't.
Now, the second part of this narrative was effectively that he was removed from his acting position without it being preempted. Now, as I understand it, he gave evidence that he understood he was in the acting position until the position of Advocate Batoy in The Hague was going to be sorted out. And that he was summoned to your office on one day and he was told, thank you very much for your service. Your colleague Advocate Noko would then replace you. And he was then replaced. And I understood your evidence to be that essentially that was a decision. She came also in as an acting DPP at that stage, correct?
I would have to look into the document, but I wouldn't deny if she came into that position
She
to act.
She was appointed. She was appointed in 2013 to a permanent position. I have those documents. Let me just find that quickly. Your evidence, as I understood it, was that that was a question of representativity.
The question of appointment.
The question
of appointment of a female was a question really of representativity in terms of gender.
And I think you might have made a mistake because I understood your evidence to be that there were no other females in DPP positions at that juncture.
Few.
There was Ivy Thenga in Kimberley, and there was one in Free State as well, whose name I can't recall right now. Kanili.
I said there were few.
Few.
If you look if you look into gender representativity, there were few. We had South Gauteng, which was also a male. We had the Western Cape. We had the Eastern Cape, two that were also male. We have the Northwest, that were also males. Yes.
Just give me a second, and you then. It's K. The memo is K 2012 number 7. Does that is your memorandum seeking the appointment of Advocate Noko? Is it which you addressed to the Minister?
Yes,
And it's dated the 26th of June 2012, correct?
yes,
Somewhere at the end.
Yes.
I accept that it's dated that,
yes.
right? And the motivation that is provided for in here at paragraph 4 is that it is to ensure adherence to the prescripts of senior management and that no expectation is created by an extended acting appointment. You deem it necessary to request the appointment of another senior deputy director to act as DPP for the period 16 July until further notice. Correct?
Yes,
So that was the motivation which you forwarded to the Minister.
as it appears in paragraph 4.
So it wasn't just gender representativity. You effectively didn't want Advocate Molocha to get too comfortable in an acting position, which is what you effectively told the Minister.
Part of the reason was that though it's not included in here, that was part of the reason.
Yeah, and it's not included in that memo. And in fact, if you go to the document just before that, which is number 6, you will see that Advocate Noko comes and sees you the following day. It's the confirmation of her travel to the head office on the 27th of June. How did you select Advocate Noko? Did you have a list of the DDPPs and then you picked the competent female in the KZN that you were going to replace Advocate Malocha with? What was the criteria you used?
I actually got assistance from a head of our, how do we call them again? Corporate managers. Head of corporate manager, our corporate manager, who was then the head of NPS, and her name is Ms. Rafule Motswane. She's been in the NPA for a number of years. She's worked under Advocate Mshe. So I got her assistance in actually in the scheme of things, into looking in particular for a person who is actually in KZN.
And effectively his evidence was that it was out in the public domain, or she put it out in the public domain, and in fact I checked the newspaper article, he was entirely correct, even before he became aware that he was going to be replaced. But you don't know anything about that, do you?
I don't know, Chairperson. That is why when I was happy when Mr. Ngasana had said that he set up the commission to investigate media leaks. We're troubled by media leaks in the institution. That is a fact.
Seems, without belaboring the point, because I went to double check, although it basically said a provincial NPA source who declined to be known told the Mail and Guardian that on Monday this week a senior KwaZulu-Natal prosecutor whose name is known to the MG told the staff that she would be taking over from Molochwa. And effectively she tells her staff that before you tell Molochwa that he's being replaced. So one can see that if that got out, it probably came from the horse's mouth. I'm speculating, so let's not take that any further. There was nobody implicated at the DPP office, either in Durban or in Pietermaritzburg, in any of the Cato Manor squad killings, eh?
You mean implicated in what way?
Charged as being complicit in any of the crimes.
But there's nobody who was charged. It was just a general statement. Yes.
Can I understand? It was just a general statement. What does that mean?
I mean, Chairperson, that those were concerns that were raised by IPID, not that there was a prosecutor who was facing a criminal charge, as Advocate Bawa puts it.
And
The process would have been, if there was such a general statement, that these concerns be aired with, what do you call them, integrity division. Was there any complaint or discussion with that unit?
There was no, I have not discussed it with the Integrity Management Unit Chairperson in particular. Really, my concern at the time was just to get the case going. I didn't want to start an investigation on prosecutors, because sometimes these things do happen, that the police would come and they would state their issues that they actually have with the case. So I felt, for me, what was necessary was to ensure that the case is actually done in a manner in which it's going to remove any perceptions from the police.
If I may, IPED and others complain about the situation in KwaZulu-Natal. I would have imagined that that's something important, that they should, even if it's after you've cleared up who is going to prosecute and how this thing is going to proceed, that this issue is taken further. Remember, if you say that you also discussed it with Mlochwa, there must have been concerns surrounding the activities in your prosecution unit there that should then be investigated. There's a concern, there's complaints, there's removal of the DPP, or not removal, but there's somebody else who comes in from another region, and you just let it go at that. That's what I'm trying to understand.
There is no one who comes from another division in the sense of making decisions about whether to prosecute or not. There is just a team of prosecutors that are taken from various areas to assist with the prosecution of this matter. As I understand, but I'm subject to correction on this one, the IPED police had reported it to their own superiors.
In lies my difficulty. You are saying that IPED may have reported it to their superiors. The NPA is being accused of lack of public trust. You have brought in people to come and prosecute because you've got concerns from another region. And I accept that sometimes you do it. You mentioned the fact that in the Western Cape, a team of prosecutors were brought in, not because anybody was complaining, but judges do it too. On the bench, you'll have a judge who's implicated, you bring another judge from another division. My difficulty is the basis or the premise was complaints about these specific prosecutors, or the head of the prosecution in Natal and other prosecutors who you actually don't know their identities. Shouldn't we then have expected that there would be a follow-up about these complaints instead of just letting them go?
Well, Chairperson, that might have been an oversight, because I think at the time my focus really was to ensure that the case goes on as it had proceeded to the state.
now, can I continue? Now, even though Advocate Noko signs the request for authorization in August 2012, she's not directly involved in this matter. It's still overseen and dealt with by Advocate Chauke. Is that so?
My understanding, Chairperson, was that she was continuously briefed. In fact, the prosecutors themselves can speak for themselves. Advocate Mayema can speak for himself. They used to take trips and travel to KZN to meet the DPP and brief her. So my understanding was that she was continuously briefed on the matter. She was not briefed by me, but she was continuously briefed by the prosecutors.
But she wasn't running it. It wasn't being done under her auspices. It was being done under the auspices of Advocate Chowki. And she says this in an affidavit which she provides, which is J97, where she effectively say, I'm not dealing with this. And it's only when Advocate Nksana comes in 2014 that I'm instructed that this matter must be transferred to me from Advocate Chowki, and that they must report to me and not to him. And up until that point, they reported to Advocate Chowki. Correct?
For the daily operations, as I understand, they reported to Advocate Chowki. But from my understanding is that they were keeping Advocate Nomgcobo Jiba informed of the developments of the case. That was my understanding. And that is what can then be confirmed by the prosecutors themselves. Advocate Mayema can be here to explain their interactions with the DPP in KZN.
And one of the difficulties which have been raised is, under what power does Advocate Chowki exercise any power to do so in a jurisdiction other than where he's appointed as a DPP?
I remember the case was not transferred from a jurisdiction in KZN. If that power were to be exercised of transferring the case from a DPP in KZN, it would have been empowered in terms of Section 22, subsection 3. The role of Advocate Chowki, as you would see in the affidavit that Advocate Mozink has prepared, was really a convenient role of supervisory functions, because some of the prosecutors really came from his office. And that is how I took it, that the role ends in actually performing the supervisory functions, not essentially to take and make a decision whether to prosecute or not.
Essentially, that decision to prosecute on the racketeering charge is taken by Advocate Noko in August and referred to you, and then on the other charges, the murder, etc., that is taken by the prosecution team of Advocate Mayema et al. Is that how it occurred?
That's how it occurred, because remember the deputies are empowered to issue and authorize indictments. Yes.
And you provided them with an authorization, which I understand you say you're entitled to do under Section 24B of the NPA Act. Correct?
Yes, Chairperson.
We're going to avoid a debate about what the conjunctive and is between A and B for argument at some point, but you acted under what you understood to be 24B.
Yes, Chairperson.
Now, you referred to an opinion that was furnished in this regard. Who furnished that opinion?
Which opinion again?
You in your evidence in direct said that an opinion had been furnished which allowed you to, which had said you could do it under those provisions. Now, it's not the opinion of Gerard Nels. I'm asking you if you can recall what opinion that was, or whose opinion that was.
Now, when I was referring to an opinion which was later requested by Mr. Ngasana when he, in a meeting, he expressed concerns as to whether our case is not going to be found wanting for lack of process. And all I was saying is that that opinion was submitted to him and he did not disagree with it. And that was the opinion that was given by Advocate Mayema.
So it was an opinion from Advocate Mayema that was provided to Advocate Mr. Ngasana.
Yes, Chairperson.
Okay. And when Advocate Malochwa says that you relied on an opinion from Advocate Nel, do you recall what he's referring to?
I think Advocate Mlochwa was referring to, he was speaking about delegations, essentially. And the issue of delegations did not require any opinion. Those opinions have been there for quite some time. And that is exercised all the time. We know that prosecutors prosecute on delegations. The issue about all of these authorizations that were issued by myself and the delegations that were issued by Advocate Mlochwa, they came at a particular time when odds were against me in terms of having made this authorization. So I just want all of these things to be understood in that context. And at no stage did anybody ever come to me to say that you were wrong by doing this, you were wrong by doing this, you were wrong by doing this.
It does seem that it emanates from a previous practice. When the Scorpions were still around, they had national jurisdiction and the prosecutors who was attached to the Scorpions could prosecute in any division. Correct?
You would still have to have some form of authorization. You can't just go and prosecute in the Western Cape, for example. Remember, there were prosecutors even in the Scorpions. The Scorpions had regional heads. Ne? So under the office of a regional head, there were then prosecutors who were actually assigned to prosecute in that particular jurisdiction. So if you have to move from Pretoria, for example, you would have to have some form of authority that authorizes you now to go to prosecute a case in another jurisdiction.
Can I then move on? I want to talk a little bit about the Breitenbach disciplinary inquiry and maybe deal with that a bit. When she was suspended, Advocate Marshal Mogatla was appointed as the acting regional head at SCCU. Correct? It might not have been immediate, but he was first appointed as the acting head and then I think it was made permanent. Is that correct? That sounds
so.
right.
That sounds familiar, yes?
Right. You were ultimately the person who had made decisions in relation to Advocate Breitenbach's disciplinary matters. You were the acting NDPP at the time.
When you say...
Let me rephrase that, not making decisions. Let me rephrase that. You were the acting NDPP at the time this was happening.
Yes, I was the acting NDPP. At the time this was happening, but that I found it on the way. It has already started. The process has already started of investigations and all of that, yes.
The process had started because the complaint had come in the October previously, and if we recall Advocate van Rensburg's evidence, you in office in January 2012, I'll get the years right, and what has by now landed on your desk is a report from Advocate Mokgoro in relation to steps which he is recommending should be taken in respect of Advocate Breitenbach.
I think the first one to happen, I'm subject to correction, is by Karen herself, where she brings me up to speed on it is not necessarily by Advocate Mokgoro. I think it was by Karen
Yes,
at the time, yes.
yes, correct. She brings you up to speed and no steps are taken. It's not a priority in your life at that juncture. And then the memorandum comes from Advocate Mokgoro also during January. I think Advocate van Rensburg's evidence was it could have been a week or two apart from the briefing and when the memorandum landed. Would that be correct?
You could be correct, Chairperson, but I'm not really sure. What I do know is that I would have said to Ms. van Rensburg that then you must continue with whatever you needed to do. Because, I mean, this is something that falls within their scope. I would not have prescribed on what she must actually do.
But you do sign the memorandum in February, if I understand it,
In February 2012.
2012, pursuant to that process relating to the suspension of Advocate Breitenbach. Let me show you the memorandum that I'm referring to.
Yes, Karen did testify to that effect that I did sign the memorandum in February 2012.
Yes. And sorry, Advocate Jiba, I'm just losing my page here and having changed documents. So I've just lost my argument page. Give me a second. I think it's at 135 of J, Mr. Majavu, where we see the memorandum. And it's dated the 13th of February, and it is a request for a precautionary suspension in respect of the disciplinary matter. I might not have the signed one because the signed one was probably provided to Advocate Breitenbach or is in some record, but this was raised at the disciplinary inquiry as well. And I think her evidence was that the letter was attached that should have gone to Advocate Breitenbach but was not signed till much later. Do you recall that?
Do I recall having seen this memorandum?
Yes. This is the memorandum which Karen van Rensburg testified and which we have the affidavit from Mr. His name now eludes me. Mr. Netangahani.
Mr. Netahangani, yes. Yes.
Which he says it was signed, but the letter wasn't signed, so it was simply went back into the employment file, and you signed it. Actually, his evidence was you signed it on the 2nd of March 2012. You approved the memorandum, but didn't sign the letter of suspension.
Yes, I remember.
Right. And do you, Advocate van Rensburg's
Sorry,
evidence?
Judge. My client has just passed me a note. She needs a comfort break, whose nature I will not reveal. Please, Judge, if you may.
Okay, yeah. We can give, what, 5 minutes? Sure, 5 or 10 minutes. I think once somebody goes, everybody would want to go. And we don't have enough facilities here. Can we give 10 minutes?
Okay.
Thank you very much. Ms. Bauer?
In, in the we started off and we were dealing with the Breitenbach disciplinary inquiry before the break. It is document in folder H 1.6 and it starts at page 586 of the bundle. And Advocate Jiba, this is a Labour Court application which Advocate Breitenbach brings. I think it's one of two that she brings, and essentially she brings the first one on an urgent basis because she says the indications are that the disciplinary proceedings are not going to be brought within 60 days, and the second one she brings the reasons I can't remember, but the one is before Judge Chele, and the other one is before Judge Rapkin Naika. Correct? And in one of the affidavits, this is the second affidavit to which I think the affidavit you do in the first one is annexed. But I just want to take you through some of the allegations made in this affidavit. This application precedes the actual disciplinary proceedings, correct? Because she's seeking to have the disciplinary proceedings made away with, and she goes to the Labour Court, the Labour Court finds against her, and then subsequent to that the disciplinary proceedings commences.
Thank you for the reminder. I was going to be lost which one came first because it's been some time that I read the affidavit. If you say so, then that is correct.
And as I understand, you did the affidavit, and you see in paragraph 2 by virtue of being the acting NDPP. Were you kept abreast of matters in relation to the disciplinary proceedings? And when I mean the disciplinary proceedings, I mean what has been going on in the matter at the time.
I must try and recall now, Chairperson.
Let me make it easy. Sorry, Advocate.
In what way abreast?
So let me do this. You deposed to an affidavit. You obviously got briefed as to what the state of play was in order for you to do this affidavit.
Yes, correct.
And from who would you have been briefed in respect thereof?
Yes, that I would have been briefed in respect thereof. There were also, Karen had a system where she would submit some reports at a certain point in time, yes. Yeah.
And so you would have been kept up to date in respect of the reports that was provided you from time to time as well?
I would say so, Chairperson, but you know, if I just had an opportunity to read the affidavit, I've not read this affidavit for quite some time. I'm worried that I'm going to give you responses on something that I last saw. I don't even know when I last saw it.
Let me see if I can switch to something you might remember a bit more and come back to this affidavit after the lunch adjournment.
Okay.
Okay. Right. You were see, this is a long story which I'm going to have to then make short as well. But let's do it the following way. I'm going back to what led up to your suspensions in 2007. But essentially, at some point, both you and Advocate Mokgoro were suspended at the same time for different events, correct?
I'll just say we were suspended. I don't know at the same time, but we were suspended, yes.
You both had actually brought Labour Court applications and you both had invoked the Protected Disclosures Act in the Labour Court matters.
Yes, in the subsequent application,
You-
after the first one was dismissed, yes.
Yes. In fact, both of your first ones were dismissed and then you brought applications for under the Protected Disclosures Act in the Labour Court.
Mine was dismissed. I don't know his, but
Right.
mine was dismissed.
His evidence was that his was because he had lodged something at the bargaining council, if you recall, and because he had done that, the Labour Court said go back to the bargaining council. Right? There were then settlement agreements concluded with both of you during that same period. Are you aware of that? Or are you only aware of your settlement?
I'm aware that there was also a settlement agreement concluded with him as well.
And those settlement agreements were signed off effectively by Advocate Mshay. He was the signatory on the part of the one side, and you and Advocate Mokgoro were the signatories on the other side. If you're not comfortable about me adding Advocate Mokgoro, we'll leave it at Advocate Jiba on the other side.
Yes, Chairperson.
Right. You then, subsequent to that, which was permitted under the settlement agreement, sought to recover compensation for the cost incurred in the legal proceedings and certain performance compensations using the procedures which you permitted to do by way of the Department of Justice. Do you recall that?
Before you answer, will you repeat the question a little bit louder? So you might just be tired.
Can you just repeat the question, Advocate Bauer?
Right. You signed these settlement agreements with, well, let's talk about a settlement agreement with Advocate Mshay.
Yes, I signed the settlement agreement with Advocate
There
Mshay.
was a little bit of a skirmish with Advocate Mshay about the terms of the settlement agreement, but that's neither here nor there for my question. After the settlement agreement was signed, you then sought to recover compensation for the costs of the legal proceedings from the department. Do you recall that?
Unless you show me something, I don't
Okay,
recall that.
let me see if I can. Blah, 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 blah. Just give me a second. It's J123. It's a big document of 81 pages, but let me take you to essentially what the, to put it into context, because if somebody is going to look at this document, there is a memo which you write on page 4 to Advocate Simelane on the 2nd of December 2009. And that might jog your memory because it's something you wrote and you summarize what had transpired before that. Right? Do you see that, Advocate Jiba?
Yes, I do see my memo.
Right. Now, at this stage, there was you were a deputy director of public prosecutions, and the legal debate which was carrying on was who actually had authority to suspend you and who actually had authority, whether it was the Minister of Justice or the NDPP. Does it ring a bell now?
Yes, I do recall.
Right. And it was in that context that you actually took one of the points in limine in the Labour Court proceedings that had ensued. Do you recall that?
Yes.
Right. Now, in the document, and maybe we should just start on your document because it gives the background. Your suspension had emanated based on the affidavit which you had provided to SABC in the context where they were doing an investigation of Advocate Null.
Yes, Chair.
Right. And you then mounted you mounted some legal challenges, and hence the disciplinary hearing didn't happen, and you then made representations to the Minister of Justice, who then directed Advocate Mshay to uplift your suspension and withdraw the disciplinary action. I'm reading from your memo on page 5, first paragraph.
Can you refer to the subheading, because this one is not numbered?
Sorry, I'm looking at the electronic page number 5, which is the first paragraph. It's under the subheading background, but it's the last paragraph.
Yes, I see background.
Right, it's the last paragraph in that section. Can we, Mr. Majavo, is your electronic page number also page 5?
No, but it's not, but you want the paragraph. The paragraph
Okay.
that starts police late uncovered.
No, it's the paragraph it's the next paragraph. The first paragraph of the next page that I just,
Due to various
legal challenges that I mounted.
Yes, yes, Chairperson.
So you made representations to the Minister of Justice, who directed that Advocate Mshay uplift your suspension, withdraws the disciplinary actions. Correct?
Yes, Chairperson.
Right? And in the next section, you detail what was your thinking at the time, that the power lay with the Minister of Justice and not with the acting NDPP. Correct? That was your opinion
Yes.
then. Right? And you believe that your suspension and disciplinary inquiry was a cover-up of the alleged criminal conduct by Null. Correct?
Yes, Chairperson.
Right. You then detail the review applications that you brought in the next section. And then in the next section, which is headed, maybe the next section which is headed settlement agreement, but maybe we should go to the paragraph just before that, because there's a context where you say simultaneously applied and was granted an interim interdict on an urgent basis, staying the disciplinary hearing pending the finalization of the court hearing involving the alleged violation of the Protected Disclosures Act. Costs were reserved. Settlement was then reached between yourselves before that matter came to court, correct? And part of the settlement agreement was the disciplinary agreement would not continue and you would withdraw the court actions in the Labour Court.
That was part of the settlement.
That was part of the settlement.
Agreement.
We'll come to the settlement agreement in a bit. But in the next paragraph, you detail Advocate Mshay never initiated the settlement of this matter. He was summoned to a meeting by the Minister of Justice. Can you recall who was the Minister of Justice at that time? Advocate Radebi. We're now in 2009. No. We in 2000, and yes, December 2000, doesn't matter.
Could have been.
Yeah. Which was also attended by the Minister of Police and the Divisional Commissioner for Crime Intelligence. That was Mr. Mluli at the time, correct?
I'm not so sure it refers Mr. Mdluli or a certain Mr. Mpekha, I'm not so sure.
Okay. And it was at that meeting that the decision was taken that Advocate Mshay must withdraw the disciplinary action and reinstate you. Correct?
Yes.
And that then resulted in a settlement agreement, and the dispute arose because he wanted to gag and silence you in the settlement agreement, and you then made certain changes to the settlement agreement which he then didn't agree with afterwards, but effectively both of you signed it. Correct?
Effectively, we both signed, yes.
Right. For my purposes, that spat is not germane, right? So there was a signed settlement agreement, and we now, which was concluded, the effect of which was that you would now come back to work,
Yes, Chairperson.
right? And if you see, just scrolling down, I'm going to pass all the communications about the settlement agreement, save to make one point that if one looks at this file, if you go to the letter which Advocate Mshay writes dated the 29th of September 2009, which I see on page 13 of my electronic documents, it says that your settlement agreement was signed by the parties on the 4th of September and 8th of September 2009. Right? Just the dates. There is some dispute about it, but the agreements essentially signed on the 4th and 8th of September. There are further documents in this bundle which show that Advocate Mokgoro is along exactly the same terms, and his get signed at exactly the same dates. Right. Now, there is then an issue, if you go further on, about compensation for occupational detriment and related expenses, which both you put in and Advocate Mokgoro puts into the department. Does that now ring a bell?
Who is that?
Your letter one will see on page Advocate Mokgoro's comes first, but let me just push it down a bit.
I'm struggling to see the letter you are referring to.
No,
Is it a letter written by Advocate Mshay to me, or is it one written by me to Advocate Mshay? Which one are you referring to?
Just give me a second, because I think it's dated. Sorry, now I'm mistaken. The occupational one is done between Advocate Mokgoro and the department, not you. I apologize.
Okay.
Right? If you go down on the document, quite near the end, I think, is a copy of the settlement agreement. Mine is on page 76. And just before this document is actually Advocate Mokgoro's document, where are you there?
Sorry, Chair. May I just get an indication from Advocate Bauer if the intention is to beam up the settlement agreement? Because you would remember that such agreements are governed by confidentiality, so she doesn't mind as long as that caveat is borne in mind? Because I see it's being beamed.
I don't need the details. I'm simply trying to sort out the dates as to when in the settlement agreement. So you don't need to necessarily put it up. I simply want to.
It's not me who's put, that's precisely the point I was raising, to say she can answer all the questions, but let us
Yeah.
not expose
Or the
her.
terms.
Not the terms, yes.
Right?
Before we proceed with this matter, can you just clarify who attended that meeting where the settlement agreement was mooted? Yeah. Minister of Justice?
It must have been General Mr. Mpejo, because he was the head of crime intelligence at that time. Remember, the General Mhloli was in Gauteng as a detective head. So I suspect it must have been Mr. Mpejo. I can go back to my records and check, because he was the one who was the head of crime intelligence.
Was the Minister of Justice? And you say Mpejo, what's Mr. Mpejo's position?
He
Head
was
of
the
crime-
one who was the head of crime intelligence at the
Okay.
time.
And who else? Just the two of them?
And there was a minister of police,
Yes. Okay.
yes. And the minister of police at the time must have been Minister Natim
Nati?
Tetwa.
What date was it?
It must have been Minister
Yeah, I
Natim
think-
Tetwa.
Okay, yeah. And this,
Yes.
this was a labor issue?
Yes, this was a labor issue.
I just wanted to understand the presence of the Minister of Police and Crime Intelligence. Okay. You know why
From-
they were there?
Well, all I did, Chairperson, was to submit my representations. I did not
You didn't
compose.
question?
Yes, all I did was to submit my representations, yes.
All right.
Maybe the question I didn't ask and I should have asked you, you were not in this meeting, correct?
Let me just go through this. That's why I said, I need to read this and recollect, because this thing happened some time ago. I don't remember.
I think
being
it
in
would
the
help,
meeting.
it would help
with
us to know exactly who
remember-
was
I
there
remember
at that
submitting.
meeting, so that we find the relevance of the presence of those people. All of those people who were there, those who were there at the beginning and those who were summoned to the meeting, and now the fact that you were not at that
I'm
meeting.
not in the meeting.
Yeah,
with
just
Advocate
get
Mokgoro.
clarity around that, né? Thank you.
Okay.
Advocate Jiba,
I will check it properly so that I can, I'm not so sure.
check
It's-
it. I seem to think you were not, but I can't say that for sure. I might have seen something in the passing that I can't recall what that said that, but I'll fairly put it that I was clearly under the impression you were not at that meeting, but I could be wrong.
I will establish, Chairperson, I'll just check.
We'll appreciate that.
Sorry, Chair, can I just raise a concern I'm having with the 2007 matter that is being, that she's being cross-examined on? It's really of relevance and the scope of the terms of reference. Are we saying that we are now investigating an event that happened 2007 when she was a DPP for purpose of determining whether she's fit and proper to have been appointed in the position of the Deputy National Director of Public Prosecutions? I mean, what is the relevance of this 2007 matter to a position that she's being investigated on that comes in 2012? I'm just wondering what the relevance of that is, unless it's suggested that there was a level of dishonesty in the 2007 matter that was missed when she was appointed as a Deputy National Director of Public Prosecution, for which it would be relevant to inquire, then I'm at loss why we are looking at the issues that we're looking at in 2007.
Or there was a link. Can you respond to that, Ms. Bauer?
I think Advocate Jiba sees where the link was, but let me explain to
Just explain.
the affidavit which results in Advocate Jiba's disciplinary proceedings and subsequent suspension is an affidavit which is furnished to crime intelligence, at the time being Richard Mluli. Richard Mluli then files an affidavit in the Labour Court application for Advocate Jiba at the time, which is a year or so prior to when the criminal matter lands up at Advocate Mokgwebi's desk. The papers from Advocate Hofmeyer to others have been fraught with some sort of a suggestion, and I actually went through it when I dealt with Advocate Hofmeyer's affidavit that he did in the matter in 2015. I don't understand me to be suggesting there's any truth on it. I'm simply answering the question of what you asked me for a link, and like I put a narrative link to Advocate Jiba earlier on, that was the narrative link to linking effectively Richard Mluli to Advocate Jiba. So the entire 2007 disciplinary proceedings results because of an affidavit that she furnishes to SABC crime intelligence at the time of which he is instrumental in getting. So the reason why I'm going there is to place on record what those links were, what those ties were, what the settlement reached at the time was reached with the employers, what Advocate Jiba came back to the office, where she went to after that, which I traversed before lunch. So if you're asking me where that link is, that seems to be the first recorded link that on the papers that's in the court applications, etc., of some contact between Advocate Jiba and Richard Mluli, which becomes material in the allegations made in the full matter, which is squarely within this inquiry's terms of reference. And I'm not for a moment putting any truth or any higher version to it, but if you're asking me why I'm starting at that point, that's the reason why I'm starting at that point.
Thank you, Ms. Bauer. You want to respond?
I do appreciate the explanation, but I'm still at loss in how, in the FUL matter, that information of 2007 is relevant. Because as I understand it, in the FUL matter, the real concern was whether or not there was a basis for not, whether or not there was the prosecution of Mluli should have continued or discontinued. That is what I understand the FUL matter to have been about. I don't believe that in the FUL matter there was any reference to the 2007 issues relating to the disciplinary hearing, the labor court matter, and all those aspects. But I hear what you say. I mean, we will argue that it was not relevant at all.
You can preserve that maybe for your legal argument. Next. Yeah. Thanks. You can proceed.
The point I was, just give me a second. Your settlement agreement was effectively reached in September 2009, where after, and you'll see that on the right last page, where after effectively, in terms of that, you would return to work, and as you testified, it was initially contemplated in the settlement agreement that with the dissolution of the Scorpions, you would be transferred to the DPP office Pretoria, and there was then an arrangement made, as you said, for you to go to the SCCU instead. Did you ever go to the DPP Pretoria?
I can't recall if I did go to the DPP office in Pretoria at all, but what I do recall is that I expressed my unhappiness about going to do those kind of cases in the DPP office.
And who did you make that arrangement with? Advocate Mzanyati or was the Advocate Samalani? Oh, it's Advocate Mshay at the time.
Yes, it was not advocate, yes, you're
That's
right,
that
it was Advocate Mshay.
And in fact, as I understand it, it was Advocate Mshay who makes the arrangement with Advocate Breitenbach for you to come to the SCCU, if I follow the link of the evidence that we've had so far. Am I correct?
It could have been him, but I also did go to Advocate Breitenbach at some point to say that I will be starting in the office, yes. But I think the higher up arrangements would have been made by Advocate Mshay.
Madam Chair, it's 7 minutes to 1. If I start on something entirely different now, I'm going to take it completely out of sync. Can we take the lunch adjournment for Advocate Jiba to read the affidavit that we discussed earlier? We could come back 7 minutes earlier.
Can we have a 45-minute lunch?
Which means what?
Which means, no, 10 to 2. Quarter to. Let's come back at quarter to. Yeah, thank you.